Hello, everyone. Good afternoon, good morning, depending on where in the world you find yourselves. I'm Adam Kolker. I am Assistant Dean and Executive Director for International Programs at Colombia Law School in New York. I'm very, very pleased to welcome you to this joint webinar presented by Esade Law School in Barcelona and Colombia. It's on a very timely topic that did not exist just a short while ago, the impact of COVID-19 on investment arbitration. We've got two experts, I'll say two of the leading experts who are on top of developments like this. I'll introduce them in a moment. But first, just a bit of background. This is a 60-minute event, and I'll invite you to send any questions you may have through the link that you've got. A bit about the partnership between Esade and Colombia. We've worked together on many different programs, ranging from exchanges of students every year, and I can say we get some of our best students, or we get some of Esade's best students at Colombia. I hope we send you their analogs. We have faculty that have taught at each other's schools, and in fact, both of the experts who will be with us today, Professor Patricia Saiz and Kabir Duggal, have lectured at Colombia in a program that I run, the U.S. Business Law Academy. We hold that every summer. We're doing it now online. We hope to be back in person next year. And in fact, Professor Saiz will be teaching a full course next July of 2021 on international investment arbitration. But to today's talk, let me just mention a bit more about our colleagues. So Professor Saiz is a professor of international arbitration at Esade Law School, where she teaches commercial and investment arbitration. She's also the academic director for international programs at the school. She's a member of the ICC International Court of Arbitration on behalf of Spain. She's acted as tribunal president, co-arbitrator, and sole arbitrator in ad hoc and institutional arbitrations. Before joining Esade, she practiced here in the United States for 10 years. She's a member of the bar in New York and Washington, D.C., and has represented numerous multinationals and governments in international commercial, investor state, and state-to-state arbitrations. Kabir Duggal, who is a lecturer in law here at Columbia, is also a senior associate in Arnold & Porter's International Arbitration and Public International Law Practice Group in New York. He focuses on international investment arbitration, international commercial arbitration, and public international matters. His experience includes complex disputes under numerous bilateral and multilateral investment treaties and contracts in South Asia, Latin America, Central Asia, Middle East, Europe, and Africa, and the total value of the disputes he's involved in exceeds $80 billion. He's also acted as a consultant for the United Nations Office of the High Representative for Least Developed Countries, Landlocked Developing Countries, and Small Island Developing States. I could go on much longer about each of them, but I want to preserve time for hearing what they have to say. Before I turn it over to you, Patricia and Kabir, I just want to set the stage a bit, because what we're going to be talking about is, again, as I said, something that didn't exist 6 months ago. And it's the COVID pandemic, and here specifically how that relates to international arbitration. States right now are under a lot of pressure to deal with it, obviously, in many different ways. But with regard to international investment, they're able to regulate the situation, and indeed, many states have adopted measures to varying degrees of severity along those lines. But the states also have to respect international obligations. And some of those obligations are contained in investment agreements, which brings us to our topic. And some of these questions: how do states reconcile the right to health with their international obligations under treaties they've entered into? I hope you two will tease out some of those answers. I will be among our audience listening closely, and I hope we've got some time for questions at the end. With that, Professor Saiz, Professor Duggal, I'll hand the podium over to you.
Thank you very much, Dean Kolker. I want to thank Professor Duggal for being here with us today. It is a pleasure to host you every time. As Dean Kolker said, governments have indeed taken drastic and unprecedented measures in the past few months to deal with the COVID-19 pandemic, as well as to keep economies afloat. Needless to say, states have a duty to address the current situation, and they obviously have wide latitude in doing so. But at the same time, the measures that they adopt must be consistent with international law. So they cannot just disregard their investment treaty obligations, notwithstanding the severity of the crisis that we're facing. So in this context where states have a duty to act, and in fact, as we will talk about in a few minutes, they have done so in a myriad ways, but at the same time, they are somewhat constrained by their international obligations. We can already anticipate that this has a huge potential for leading into a flurry of claims that might come up in the coming months and years. And some of those claims may or may not be legitimate. So this is something, or some of those claims may be claims that states can successfully defend against. And this is something that we're going to discuss as well today. I'm going to proceed with the presentation. I want to show you the structure of our presentation today. And as you can see, Professor Duggal and I have divided it in 4 sections. The first section is an overview of what investment arbitration is. And this is because we're aware that the audience may not have a background in this field. So Professor Duggal and I thought it was important that we provide some context as to where these international obligations come from. Why are states subject to these restrictions? They're actually self-imposed, as we will see, but where do these obligations come from? So we're going to do an overview really quickly over investment arbitration so that we can bring everyone up to speed. Then we're going to focus on the different policy responses to COVID-19 globally. So we're going to see measures have varied quite a bit, ranging from measures destined to protect public health, to protect the economy, to protect national interests. So very diverse range of measures, and why those measures, we're going to talk briefly about why those measures might potentially be a problem in the sense of triggering the liability of states. Next, in the third section, Professor Duggal is going to talk about the possible state defenses that states might invoke, because in a situation as severe as this, as we mentioned earlier, states have quite a bit of leeway precisely through some of these exceptions. So this is something that we're going to talk about. And last but not least, we're going to talk about threatened claims to date. There have not been any cases brought as a result of the measures taken under COVID-19 so far, but different investors have threatened different claims. We're also seeing states invoke the COVID-19 crisis in different contexts related to investment arbitration. So we're going to talk about those too. So this is the roadmap for what we're going to try to accomplish in the next roughly 50 minutes. I'm going to start talking about investment arbitration and an overview of investment arbitration. Again, this is just to give context and so that everyone understands why some of these measures that states are taking might trigger that international liability of states. When we talk about investment arbitration, we're talking about a hybrid. Investment arbitration is really, or the protections under investment arbitration were designed to attract foreign investment. So states wanted to attract particularly foreign direct investment, and in figuring out how to do that, they came up with a system where states committed to do or not to do certain things. And when I'm talking about doing certain things, I'm talking about committing, when they enter into a treaty with another party, committing that they're going to treat the investors of the other party in a fair and equitable manner. And of course, that's a very wide concept, and we're not going to go over the content today, but that's what I mean when I was saying they commit to do certain things. I will treat your investors in a fair and equitable manner. I commit not to do certain things, not to misbehave. I commit not to expropriate your investors without adequate compensation and so on and so forth. So there were a few obligations, again, that are self-imposed in the sense that states voluntarily enter into these agreements because they want to attract foreign direct investment. At the same time, so this is on the left side of the screen. On the right side of the screen, and here was an innovation that came about at the end of the 1950s, 1959, with the Germany-Pakistan bilateral investment treaty, when for the first time a diagonal clause was included. And when I say a diagonal clause, it really means that states agreed that an investor that qualified for the protections of the treaty would be able to invoke the protections of the treaty and take the state directly before an international tribunal, even though it was not a party to that treaty. So that was new in 1959, and then it picked up massively in the 80s and 90s. There was a boom of entering into these treaties. Today, we have more than 3,000 investment protection treaties. We'll talk about some of this later as well. And here, what was new is that states said, look, I commit to a certain set of obligations vis-a-vis the investor, but if at any point the investor considers that those protections have been violated, then an international tribunal, a neutral tribunal, may vindicate the investor's expectations if the state disregards its commitments. And the way we're going to do this is by importing a mechanism from international commercial arbitration. So we're going to take the state before an international tribunal composed of private individuals. So this is the framework for investment arbitration, and this is what we're going to be debating today. So in the process of entering into these agreements, states entered into a set of obligations, and they are subject to those obligations today, despite the crisis that we are facing. I'm going to turn this over to Professor Duggal, who's going to give a little bit more detail as to the obligations that are included in the treaties.
Thank you very much, Professor Saiz. Let me just start off by saying how delighted I am to be here. It's Friday morning for me, and these days with the pandemic, right? Shaving has become optional, taking showers has become optional, wearing pants has become optional. So anything that forces me to do all of the above, well done. And for folks in Europe, I take my proverbial hat off to you. It is Friday evening and you're here to hear us talk about arbitration, COVID, obligations under treaty. So I think both Professor Saiz and I really are grateful to you. If I may also just add, it is always an honor to work together with Professor Saiz. I have known her now for over a decade. She was a superstar even at that stage, and I've seen her career really blossom. She is indeed becoming one of the biggest names in arbitration, and I can't wait to see what the future has. If I may also add, and this is my moment to take revenge, Saiz interviewed me 11 years ago, and she took me as a part of the interview for a welcome lunch to the like everything Professor Saiz does. It was the super fancy restaurant in DC. And in course of the interview, she asked me, so what are your hobbies? And I tell her, I like to do yoga. And she tells me, actually, with a straight face, why don't you demonstrate and show it to us? And you can just imagine the scene, right? We're in this super fancy restaurant in DC, and I'm putting my hands up, I'm lifting my leg. That is, I think from all the interviews I've done in my life, this is one I will never forget.
There'll be revenge for this at some point, for bringing up this war story.
But I think just to circle back on this point, we have collaborated in Madrid, in Barcelona, in New York, in DC, in so many cities. And that's something very special about arbitration. I know Patricia is right now in Spain. I'm here in New York. but opportunities like this just show us how we can all work together. So I'm really, really grateful for everything with you, Professor Saiz.
Same for me.
Let me just come back to the issues you had raised, and as I think you very beautifully explained, right? These are obligations states have entered into. These are obligations that are voluntarily agreed, right? These are things, if they're bilateral, it's one state signing it with another state. And to date, we have around 3,000 or so such treaties. We call them bilateral investment treaty, BITs. Multilateral if it's more than two states. Now, I'll just put a slight footnote here. Europe, obviously competing with the United States for doing controversial moves, has recently adopted a policy where they're going to terminate all intra-EU treaties. This flows out of a very famous / controversial, based on how you see the world, decision, the famous Achmea decision. So this 3,000 number may reduce for intra-EU treaties, but we have to, take this just with a pinch of salt. At a high level, this is intended to indicate how prevalent this regime is, probably the most prevalent regime in international law at large. And these treaties give obligations to investors on things like, we will not nationalize, to use the fancy term, we will not expropriate. And if we expropriate, we will give you fair, prompt, and adequate compensation. This is one of the obligations. The other, you're agreeing in your treaty to treat an investor in a fair and equitable manner. What is fair? What is equity? These are meta questions in life, but that's the obligation you're assuming. And you're also agreeing to treat an investor in a manner that guarantees the investment full protection and security. The next point, and if you look at the theories of investment arbitration, this tends to be a core value and it manifests itself in a variety of ways. But the idea here is don't discriminate. Right? Treat your foreign investors like you would treat domestic investors, like you would treat other foreign investors. This is a big value, right? You want to make sure they're getting equal treatment. Professor, if you could move to the next slide. Thank you. Just a little bit more. Another obligation is to have free transfers, right? You want to make sure that an investor is able to take the investment out of the country without too many restrictions. The treaty will give you the parameters of how to do this, but you can get the idea on the obligation at a high level. Now, the next point, let me also just make one general disclaimer here, that we are talking at a very high level here, but we're going to get into sufficient detail. Now, this is always the challenge you have in a presentation like this. And I also want to just add, I like making slides and I like using, this word is up for controversy. Is it GIFs or GIFs? But these beautiful slides have all actually been put together by Professor Saiz. And again, I take my hat off to you. Someday you have to teach me the skill to do this. Because it does look very beautiful. I'm just looking at it in admiration. The next point that we're going to talk about is some treaties agree that we will protect the making of an investment. We call that as a pre-establishment guarantee. That is, when you are making your investment, the act of making your investment will be protected. Now, this was a provision we found in this continent, in North America, in a treaty that existed till 10 days ago. It used to be called as NAFTA. As you can probably recall, a few years ago, life as we know it changed because of US elections. One of the consequences of that is NAFTA died, and NAFTA took a rebirth on July 1st. Nobody knows how to call this. I like to call it USMCA, USMCA, the US-Mexico-Canada Agreement. So that's NAFTA 2.0. And that, has this idea, we will protect your making of the investment. Most treaties don't. Most treaties only protect an investment once it's made. And I just end with the point that Professor Saiz made, because this is critical. You are agreeing in this treaty that if you have a dispute, your dispute is not going to be resolved before the usual forum. That's domestic courts, right? If you have a problem, go to court. You are agreeing that if there is a dispute on these treaties, the dispute will be resolved by an international panel of 3 people. And of those 3 people, you need to convince 2 people that you were right? The system works on a majority, so 2 out of 3. That's the method that you have mostly agreed to resolve your disputes. With this, I'm going to pass the proverbial stage back to Professor Saiz to continue the discussion. Professor?
Thank you very much. So we're moving on to the second block, and now we're starting to focus more precisely on what has happened as a result of COVID-19 around the world. So we've done the context, and now we're really starting to get into the details of what are the policy responses that states have taken around the world. We're going to see this is generalized because unlike other health crises, this one affected all countries pretty much. And so this is not a regional issue. This became a global issue. So we're seeing that these measures that are quite drastic taken everywhere, essentially. So if we start to focus on policy responses, I've divided this in 3 sections. One are measures that have been taken to protect public health. So these are immediate measures that were taken when the outbreak came up to protect the public health of the population. Then we have measures that have been taken to sustain the economy, short-term and long-term. And we also have measures to protect national interests as well as strategic sectors. We're going to get into the details of some of these measures, and we don't have a lot of time, but we're going to highlight why some of these measures could be controversial or could butt heads with the international obligations of the states. So if we focus on the protection of public health, everyone knows we've pretty much all experienced extensive lockdowns and curfews to different extents as well. And so that has had a clear, obvious impact on non-essential businesses that were not able to operate remotely. So those businesses have suffered losses because of these measures. We've also seen governments take over private property, like hospitals and clinics in Spain, masks in France. So around the world, we've seen that temporary taking of private property, and that starts to ring a little bit like a potential expropriation if this were to last, if the government doesn't give that property back to the investors. So we'll talk about this in a minute. We've also seen measures to address shortages in certain goods. So for example, under the US Defense Production Act, we've seen the government order the production of specific goods like ventilators, like masks, like PPE, for example. And we're also seeing, to address shortages, limitations on exports, again, typically of medical material, of drugs, of sanitizer products, and so on and so forth. And there is an UNCTAD research dated April 14th, 2020, that highlights there are at least 47 countries that have implemented one or more measures affecting products or subproducts related or used in the public health response to COVID-19. So obviously those limitations affect investors. And if those investors are foreign, they could potentially have a claim against the state that is imposing those measures. We've also seen IP being instrumentalized. There are 4 countries that we have identified, Canada, Chile, Ecuador, and Germany, where here the idea is that states have passed legislation to encourage the joint use of IP-protected technologies with the idea of speeding up R&D and to facilitate the mass production of treatments, diagnostics, and vaccines. So again, this is something that could potentially create difficulties for investors and potentially become a claim against the state. So what are these kinds of measures? What do they make us think about? I mean, Professor Duggal, you might have a different view, but definitely expropriation if the measures last for a sufficiently long time without adequate compensation. Expropriation if the state doesn't turn back control after the outbreak ends, for example, or if the state's managing of the investment leaves permanent damage in the investment. So here there are some issues, some facts that could ring of an expropriation claim. We could also see claims for a violation of fair and equitable treatment, for example, with export restrictions. Were they reasonable, proportional? Did they have the right duration? So these kinds of issues are the issues, if we're now putting together the facts associated with COVID-19, with what we just talked about in the previous section, the protections that states afford to investors of other signatory states. So these are the issues that we're starting to see. So in the protection of public health, some measures might be controversial. We're moving on to the next block of measures, and here there are quite a few. I'm just going to go over a few of them. These are measures directed at sustaining the economy short-term and long-term. And here, unlike the previous section where we're talking about protecting public health, where by nature, those are going to be measures that tend to be restrictive, here we're talking about benefits that are given to specific industries, to specific investors, to specific to different groups. So I can say, for example, that I got a check from Donald Trump on my mail in my home in Spain. So that was a surprise. But these are measures that, unlike the measures we were talking about earlier, they're not restrictive of the rights of a particular set of investors. But what they might do is they might discriminate between certain investors and giving some investors the benefit and not others. And so if we see measures that tend to benefit domestic investors as opposed to foreign investors, then we could potentially have a claim for discrimination. And that would come under national treatment, because the argument there is, well, they're being treated, foreign investors are not treated as well as domestic investors, or what we call MFN, most favored nation clause. You're treating some investors better or worse than other third-party investors. So the bottom line here is these are measures that are designed to sustain the economy. They're positive measures, but in doing that, in granting these measures, there could be instances of discrimination where national industries are being particularly protected or preserved, which we'll talk about as well, how that could be a legitimate objective. So here, the measures that we're looking at, financial benefits, I'm going to run over these quickly. Loan guarantees, bailouts, for example, in the US for the airline industry, one-time payments. Here I'm saying the Netherlands, but Donald Trump just sent me a one-time payment in a check. Cash flow support, working capital support, subsidies for employee wages like in Brazil, and the list is endless in terms of financial benefits. We're also seeing the suspension of energy payments or forgiveness of rent, fiscal benefits, other relatively drastic measures, the acquisition of equity in certain companies, or directly a partial or full nationalization of companies, as was the case of Alitalia in Italy, to prevent the bankruptcy of specific strategic companies or industries. We could also see changes in policy. For example, we're seeing this in the US where some environmental requirements are being relaxed to the extent that the investors can prove that the non-compliance with the requirements is due to the pandemic. So policy changes long-term, we could see incentives for the enhancement of contracted economic activities. We're seeing that in Brazil, where there are packages that are offered to promote tourism, which of course is suffering, or cases of facilitating investment like China. So here again, this rings, unlike the other measures where we're talking about expropriations, this rings of, well, you are supporting perhaps some industries, local, national industries, and not others, and promoting your domestic versus the foreigners. And so this could, again, give rise to claims of related to discrimination. If there's a nationalization of a foreign industry, then we'll talk about expropriation as well. So these are the kinds of issues that we're looking at. And the last point I wanted to talk about is, so we've talked about measures devoted to protecting health, public health, measures devoted to protecting the economy, and we're also talking about the protection of national security interests and strategic sectors. And here we're seeing what we call the application or reinforcement of what we call the FDI screening. So there's a screening with foreign direct investment as to where that capital is coming from, and with the idea of preserving industries that are strategic and essential at the moment. And of course, we're looking at issues such as health, infrastructure, pharma, and so on and so forth. We're also seeing measures that restrict the ability of foreign capital to acquire stakes in distressed companies in critical sectors, not related to COVID-19, but in critical sectors for a particular country, that are, because they're distressed and because they're in need of cash and cash infusions, they might be particularly vulnerable to hostile foreign takeovers. So here again, if these are measures that restrict the ability of foreign capital to come in, and if, as Professor Duggal mentioned, there is an obligation to not discriminate with respect to the establishment moment in the investment process, then we could have another potential claim in this regard. So I think we're moving on. I'm turning the floor over to you, Professor Duggal, for possible defenses.
Thank you very much. So folks, as you've just heard from Professor Saiz, states are adopting a lot of measures in response to the pandemic, right? And as Professor Saiz also mentioned, you have these treaties that give you these host of obligations that you have to respect, right? So when you have these measures that may impede the obligations, what might a state do? Now, international investment law at large does offer you two avenues for a state to raise defenses in response to the actions that an investor is challenging, right? And these two avenues are actually the two sources that we have in international law, the two principal sources, right? It's treaty law, and customary international law. Now, let's spend a few minutes talking about treaty, and then we look at custom, right? Treaties operate as, and I'm going to use the fancy Latin word, the lex specialis, or the specialized regime. Why am I using Latin? This is something Professor Saiz and I always joke, right? The phrase is quid Latine dictum sit altum sonatur. It's about the only phrase I know in Latin as a complete sentence, and it translates as anything in Latin sounds sexy. But treaties are your specialized regime. This is what the states have agreed. This is what the bit and the mit tell us. And if the states in the treaty created carve-out, created defense, created exceptions for health measures, that's the first thing that a state can point to. look, we gave you, the investor, all these protections, but we also preserved our rights. We also, we the states, we also carved out provisions to protect health. Now, quick point here, states typically did not do this, at least in the older generation of treaties. To the extent that they have done it, this can be the first point that you can look at. Okay? The question that we're going to talk about very soon is, if you have such a provision, what can a tribunal do? In legal discourse, we call it, is the clause, is your defense clause self-judging or is it not self-judging? Stay tuned. Let's just put a pin in this for a moment. We will come back to it, but let's just look at the other category. If your treaty is silent, does the state have defenses? And the answer is yes. You have defenses under customary international law. These are defenses not just for investment arbitration. These are defenses for international law at large. And these are created, well, I should take that back. These are recognized by the International Law Commission. What is the International Law Commission? It is a body comprising of 34 members from different countries that get together in a fancy room and they discuss looking at principles and practices to tell us what customary international law is. And they give us here a series of different defenses. For our purposes, we're going to look in and out at force majeure, distress, and necessity. The last three, because these three become probably the three big buckets that we're going to see states likely invoking. Alrighty, this is the framework. We'll now look at treaties and then at custom. Professor, with your permission, we move on to treaties. Okay, and the first point we're going to look, if the state has put a provision in it, can the state just point to that provision and a tribunal has to accept it? In other words, who decides whether or not the defense validly exists? Is it the state saying it's our determination or is it the tribunal? In other words, is the clause self-judging? Is it what the state says it is? Or is it something more than self-judging? And this is where words matter. Words matter in life generally, but for treaty interpretation, they really matter. Now, I just point this out because slight differences in wording make a huge difference. We look at the example, the first example, which is the US-Mozambique treaty. And here the states say, nothing will preclude a party from applying measures it considers necessary. The word it here refers to states, right? So nothing precludes a state from applying measures that the state considers necessary, right? This becomes a self-judging clause because the state is reserving the power to itself. Now compare this with the US-Albania treaty, which says the treaty shall not preclude a party from applying measures. You're preserving your right, but you're not preserving the right explicitly to yourself. This clause becomes a non-self-judging clause. With a clause of this nature, a tribunal can look in at much greater level to see whether or not the standard applies. Now let's just go back to the first example, the clause that is self-judging. What can a tribunal do here? Even in this situation, a tribunal can do a good faith analysis, right? So in both situations, self-judging or not self-judging, there will be some review by the tribunal. If it's self-judging, the review will be much more limited. It's a good faith analysis. If it's not self-judging, the tribunal will really look to see whether the defense is applied beyond just a good faith analysis. You can do things like a proportionality analysis. Alrighty? This is the treaties. Again, just keep this in the back of your mind. Treaties typically didn't provide for a lot of these defenses. And that takes us to the other aspect, to customary international law. And we're going to look now at the three provisions: force majeure, distress, and necessity. We'll get into this relatively quickly. Just one very quick point. These are defenses in custom that apply to international law at large. And international law wants state to respect their obligations, right? What is a defense doing? A defense is taking you out of your obligation. And that is as a matter of principle. Don't think of the pandemic, but just think of law at large. Anything that's taking you out is generally seen with skepticism. We want you to respect your obligations. And therefore, as you will see, the three standards have set a bar that is super, super high. Muy alto. As Patricia knows, I always joke and tell her, I am honorary Latin. Cabiro, soy cabiro. So the standard here is very high. Now, remember, these are standards where the criteria differs from commercial arbitration. So don't think of standards that would apply in contracts. These are the international law standards. For force majeure, a state can show if it is irresistible force, it's an unseen event, and it must be beyond the control of the state, and it makes the obligation materially impossible. You can see we're using very powerful adjectives to show how serious we are, that the bar is high. And we say that the defense will not apply if you cause the action. You, the state, caused the action, or if the state has assumed the risk. Remember, these are defenses the state is invoking, and the state is going to have to prove each of these criteria. Right? Now, distress. Distress is an action that a state is taking. Just colloquially think of it, I had no other choice. I had to do it. Right? Think of a plane. Now, if a plane is flying and there's an accident and a plane is forced to park itself in another country's territory without permits, you will invoke a provision like distress. I had to do it, right? And this is the standard. There must be no other reasonable way to save lives. Remember, just think of it. If the minute you can show a reasonable alternative, the standard doesn't apply. Again, it doesn't apply if you were able to prove this criteria. It doesn't apply if it is due to your own conduct or if your action is going to cause greater harm. This is the proportionality analysis. Professor, please. Professor,
and you can see how there is potentially going to be a debate as to whether states acted quickly enough, if they were diligent enough, if they could have foreseen some of that, what happened, if they could have prepared better for it. So all of that, and we can think of countries that are currently not able to flatten the curve, and was that due to conduct of the state, which is doing or not doing what it was supposed to do? So all that debate comes into play when we look at the defenses of the state.
Fully agreed. Fully agreed. I think you're putting the context beautifully, because that is exactly going to be the central debate. You know, it's easy to look at it one way or the other, but these are highly contested issues and very specific obligations, which will lead to the sort of granular analysis you just prompted us and urged us to think about. So I'm very grateful for that. So we have force majeure, we have distress. Now, I'll just put a very quick thought here. Both these defenses have not come up too much. The defense of necessity that Professor had just pointed us to on the next slide, that we have seen some amount of application, right? Now, necessity, this is the defense where a state says the measures I had to adopt were necessary, right? And the standard here is you can invoke necessity to safeguard an essential interest against grave and imminent peril. as long as it doesn't impair a core obligation. Just think about it. If you're breaking it down, there must be an essential interest that you are protecting against grave and imminent peril, and it is not violating a core obligation. And we have two more caveats. You cannot invoke it if the obligation does not permit a defense. This becomes so generally things, like genocide, where you cannot contract out. Or if the state has contributed to the issue in question. And this again gets back, I think, very beautifully to what Professor Saiz mentioned. Did the state do it promptly? Did the state act responsibly? Was the state prepared? This ideas of this pandemic started in December. If your country got hit in March, you had like 2 or 3 months to factor in realities. Did you? All that analysis comes in here. Now, let me just also point out, this defense became central to Argentina. Argentina in 2001 had a very, very severe economic crisis. Honestly, it was like, I think in a week, they had like 5 presidents come and go. Heartbreaking from an economic perspective. But when Argentina wanted to rely on this defense under customary international law, the reaction has been very mixed. 3 tribunals, CMS, Enron, and Sempra, rejected it. Enron and Sempra will get annulled on different grounds. They'll get annulled on grounds that the tribunal didn't apply the appropriate law. But the finding here shows you that, even for a very severe crisis, you may not always find the defense becoming a defense. It's going to be the granular analysis that you just heard about. One tribunal, Continental Casualty, said it does apply. Remember, same measure, reasonable minds taking different approaches. And finally, you have the tribunal LG&E. And LG&E takes a third approach. They tell, yes, the defense applies, but the defense applies for a very particular time period when your crisis was really bad. The minute the tribunal gives us a 2-year period and says, the minute the crisis ended, you had to resume your obligation. Now, apply this framework to the pandemic, and you will see how the application of any of these defenses may or may not play out. With that, Professor, let me pass the floor back to you so you can talk about what we see happening today around us.
Great. So we're moving on to the 4th and last section of our presentation. I think we have a little bit over 10 minutes left. And we're going to talk about threatened claims to date. As we mentioned, there aren't any investment claims that have been brought as a result of COVID-19 measures so far, but they have been threatened by different investors, in particular against Mexico and Peru. We'll talk about this briefly. And then we're seeing other incidents, other things happening in the investment arbitration world where states are invoking COVID-19 to prevent the enforcement of an award or to deal with issues in the proceedings. But we'll talk about this in more detail in the next few minutes. So when we talk about threatened claims, the first country that comes to mind is Mexico. Mexico has imposed in the last few months new restrictions on renewable energy production, citing a presumed, and I'm saying presumed because there's a debate as to what the real rationale behind the measure is, due to a fall in demand as a result of COVID-19. And so the government is saying, well, because of that fall in demand, we now have to impose this restriction on renewable energy production. The measures in particular give non-renewable electricity, okay, so fuel, fossil-based fuel, they give preferential grid access, and also they give the Federal Electricity Commission a more proactive role in planning the electricity sector. So what we're seeing here is that some, and again, I'm saying some because I want to present the two sides of the arguments that we're seeing. Some argue that COVID-19 is being used as a pretext to allow Pemex, which is their state-owned, relatively struggling company, to sell fossil fuel-based energy, and also to boost the monopoly of the Federal Electricity Commission. This has had a negative impact on 44 solar and wind projects, and the impact of that is quantified at more than $6 billion US. So this is these investors are making noise, and we're seeing this in the news, and we're seeing this in the blogosphere of investment arbitration. Some investors have successfully challenged the measures in local courts, but others may not succeed, and then we might see these claims being brought forward to investment arbitration tribunals, which, again, just to make one distinction, we're not going to a local court, which might or might not be independent and impartial. We're taking this to an independent international tribunal in the hopes that they'll be less biased, right? So that's the point of what is happening with Mexico. Moving on to Peru, because I think we have roughly a little bit less than 10 minutes now.
Thank you, Professor. Just to talk about Peru very quickly, I think Peru had, a series of tolls, and many of these tolls had been given to private parties, right? And when the pandemic started, Peru adopted a policy that no company can collect tolls. Now, if it's the state, it's one thing. Building tolls is one of those things the state, an investor, or whoever has built the road, has to put in a lot of upfront capital, and then you recoup it through tolls, right? When a government passes a decision like this, right, it has a very severe impact if you are the company. Now, again, as Professor Saiz said, there are always two sides to a story. From a government's perspective, the answer is going to be, look, we want people to go home so they can be in lockdown. And if we're going to make people start paying heavy tolls, they're not going to want to go home, right? Again, this becomes one of those things where reasonable minds can look at a situation and can disagree. But this is the reality we are seeing in Peru, that the measure that the state has adopted is leading a lot of companies that have toll collection as their business, saying, hey, this is not rational. Could the government pay for the tolls? Just putting a hypothetical idea out there. I'll stop there just in the interest of time and pass the floor back to Professor.
Great. So next we're seeing in Guatemala, this is not an actual threatened claim. What we're seeing here is that Guatemala has asserted, in the process of enforcement of the ICSID award in the case of Teco versus Guatemala, they have argued that the enforcement of the award before a DC court should be stayed. And the rationale in their argument is that the country cannot be deprived at this time of the resources that are necessary to fight the virus. So again, we're seeing this is not, like I said earlier, this is not a threatened claim, but we're starting to see some ramifications in the investment arbitration world of COVID-19. And I think this is our last one. So back to Professor Duggal.
Thank you, Professor. Again, just to follow in a very similar situation that Professor Saiz spoke about. Look, we know another instance where Bolivia has relied on the pandemic as a defense. So here Bolivia is involved in an investor-state arbitration, and Bolivia tries to rely on the pandemic to say it cannot prepare to make its submission in time. The council was in Paris, and as you know, Paris had a lockdown for a very long time. The other council was in Washington, D.C., again, badly hit, although the U.S. management, oh my God. And then Bolivia, as you may recall, has, in addition to being hit by the pandemic like every other country, also had a change in government, right? So their argument is, look, how are we going to prepare this? But they tried to rely on the defense of force majeure. Now, this is, again, how you present your argument may impact how a tribunal may ultimately decide it. because the tribunal's decision looking at force majeure, which we see, has a super high bar, muy alto, rejected that defense, saying, hey, there are alternatives for you to go forward with the preparation of your defense. Query whether if you would have presented this in a different manner, may you have seen a different outcome. I know we are in the realm of speculating here, but I just present that as an idea. With that, I will pass the floor back to Professor Saiz.
So we're getting to the end of our presentation, and I have had a question come through that I'm going to ask Professor Duggal to address first. It's a controversial question that is also running around the blogosphere, is should an immediate moratorium of these kinds of claims be implemented at the moment so that states can focus on defending their cases, protecting against the pandemic, as opposed to defending against claims that might or might not be legitimate. And this, I just want to give a number so that people can put into context what it takes to defend against one of these claims. But a full proceeding in investment arbitration is quantified at somewhere between $6 to $8 million in terms of what it costs to defend yourself. So the question here that has been running around is, should an immediate moratorium of these claims, impeding the filing of these claims, be implemented at this time so that states can focus on the health crisis, the economic crisis, and not on investment arbitration? So, Professor Duggal.
You always like to ask tough questions, right? Like the yoga.
Exactly.
A very tough question. Look, obviously, the pandemic, as you said, has affected all of us. And we definitely want the governments to be focused on the immediate, the health as you had described it, and on the larger economic consequences. So we definitely look at that as a priority. So I definitely do think the idea of being very strategic about issues like this is a good one. We should welcome it. Having said that, pandemics are generally crises lead to drastic measures that can violate human rights, right? That can lead to severe. I have some empathy for a position that, we're already seeing claims that minorities are being targeted, that actions are being taken in a disproportionate manner. And if you're a foreigner that's not popular, you may likely fall in that category. Maybe one way to think about it is maybe we need expedited procedures. We need better, security for cost measures. We need, a moratorium. I don't know, but we could definitely make the system a lot more efficient, do it a lot more quickly, look at early dismissal procedures. I'll stop here, and I want your reaction.
Well, I have to agree with you. I mean, I think it's evident that states should be focusing on the health crisis, the economic crisis, and perhaps not have to face these huge bills from lawyers, experts, and so on and so forth to defend their cases. At the same time, suspending the protections is a Pandora box for abuses. Not all players are equally clean. And so you wonder if some states might take the opportunity and the disguise of COVID-19 to implement measures that maybe they've been waiting for years to implement, but they have not been able to because they were subjected precisely to this regime, which was constraining them. It's like a straitjacket. There's so much movement that they can make, and if we suspend it now, if we implemented a moratorium, then who knows what could come in. So these are difficult questions. Definitely, I think we are running out of time. We are almost at an hour. So there is a question from the audience that I'll just address quickly. Someone is asking, is there anything investors can do to plan ahead in anticipation of further measures? I'll respond perhaps, and then Professor Duggal, maybe if you want to add something. the standard in investment arbitration is that once a dispute has arisen, you cannot restructure your investment to access the protections of a particular treaty. But if you do it way before the dispute arises, we're talking about investment protection planning, just like we talk about tax planning. So definitely something to think about, because we are seeing that some of these measures, some measures have already been implemented, but some measures might be, this is not going away anytime soon. And we're going to see, again, a flurry of measures as well in the future months and years dealing with this. So definitely something to think about. I don't know if Professor Duggal, you have anything to add to that?
Nothing to add.
Well, I think with that...
You said less eloquently, so I stopped here.
Professor Saiz, Professor Duggal, thank you so much. This is very interesting, and as we said at the top of the hour, very timely. I'm just going to try to summarize, as a non-expert, what I heard. One is that we're far from the end of the pandemic and the end of implementation of measures by states to deal with it. And so it's too soon to say, but with that said, it is easy to anticipate a flurry of claims against states arising out of states' responses. What I heard is that investors should be thinking ahead and planning for protection, and states, as they implement measures, must be careful to ensure that they're not more restrictive than necessary and don't disproportionately burden foreign investment interests. A key is to ensure that the cumulative response does not conflate distinct phases of the pandemic that require different approaches. With that, seeing our time, I think it's time for us to sign off. I want to welcome everyone, all of our colleagues around the world who joined this. I want to invite Professor Saiz and Professor Duggal to repeat this in person in New York as soon as is reasonably safe. Okay, everyone, have a good weekend. Thanks so much. And for Colombia and Esade, it's been a pleasure.
Thank you both. Thank you both.
Thank you. Likewise. Bye, everybody.